Item 2. Next week, the Supreme Court is going to debate whether the Voting Rights Act is constitutional. Now, the Voting Rights Act is an attempt by the federal government, Congress, to pass a law to make sure that people of color have the ability to vote. And the Supreme Court, the buzz is that the Supreme Court is going to find this unconstitutional. So let me just, I'm going to throw this out to you for the common sense test. Just plain old common sense test. The 15th Amendment to the Constitution, which has to do with the right of African Americans to vote, freed slaves at the time that this was passed. This was ratified on February 3rd, 1870. The 15th Amendment is 2 sentences long. This is not rocket scientist, and it shouldn't require a constitutional scholar to figure out whether Congress has the power to create legislation to make sure that black people are not discriminated against. That's the case before the Supreme Court. It's going to be argued that, no, Congress overreached. Congress did not have the power to make sure that black people can vote, or people of any race, directly as a consequence of their vote, that their right to vote has not been infringed. So let me read to you, listen carefully, the entirety of the 15th Amendment to the Constitution of the United States. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. That's Section 1, one sentence. Section 2, the Congress shall have the power to enforce this article by appropriate legislation. Period. Full stop. So, number 1, can't discriminate based on race. Number 2, Congress can pass laws to make sure that doesn't happen. And the Supreme Court is going to blow this up. How? This is going to be a real interesting one to keep, and especially after Joe Madison says, he talked to the President of the United States yesterday, and the President said, get ready. That says to me that we have a Supreme Court that is not interested in being the Supreme Court. We have a Supreme Court that's interested in being the kings of America. That we have devolved to a constitutional monarchy, where the monarchs are the 9 men and women who sit on the Supreme Court, because they have the power to dissolve laws. In the United Kingdom, the Queen has the power to dissolve Parliament. She is sovereign above all. Here in the United States, the Supreme Court fills that role. It was not the role envisioned by Congress. Not at all. Okay, I also promised that I would share with you my theory on Mercury going retrograde. I learned, and actually I'll do that a little. I'll do that in the third hour. Let me get back to that. But the Supreme Court is claiming that they have the power to dissolve these laws, and yet Article 3, Section 2, the Supreme Court shall have appellate jurisdiction both as to law and fact, with such exceptions and under such regulations as the Congress shall make. Does that not make the Congress superior to the Supreme Court? And yet the Supreme Court is going to strike down a law passed by Congress? What's wrong with this picture? I think this is totally bizarre. This is a classic example of, the conservatives scream about, judicial overreach and judicial activism, their specific examples are Brown versus Board of Education in 1954. You can't have segregated schools, and Roe v. Wade in 1973. A woman has the right to have an abortion within limits. And you could argue that in both cases the court was making law. I would actually buy that argument. But for conservatives to yell and scream about Brown v. Board and Roe v. Wade and then say, oh yeah, and by the way, please knock down the Voting Rights Act, I think there's something really wrong with that.